Dear students, I welcome you to another lecture on company law. In today's lecture, we shall discuss the disadvantages that follow from incorporation. In this lecture, we shall understand the disadvantages of incorporation. We shall also understand what is meant by the concept of lifting of the corporate veil. We shall also understand whether a company is entitled to citizenship or not. Dear students, the concept that a company is a separate legal person distinct from its members is one of the cornerstones of Indian company law. It allows a company to perform juristic acts in its own name as well as to sue and be sued. Members and directors enjoy protection against personal liability. Although this cardinal principle has great influence in company law across the globe, including India, it cannot be absolute and must allow some exceptions, where the courts may disregard the legal personality of the company. The reason why exceptions exist can be classified into two categories. Firstly, even though a legal personality is attributed to the company, it cannot really be treated as a natural person, as it is incapable of committing a crime which requires the existence of mens rea, unless the courts determine the intention of the directors or the members. Secondly, strict recognition of the principle may lead to an unjust or misleading outcome if interested parties can hide behind the shield of limited liability. Thus, judicial discretion and legislative action also allows the separate entity principle to be disregarded where some injustice is intended or would result to a party either external or internal to the company with whom the company is dealing. Justice Jenkinson in Dennis Wilcox Limited versus Federal Commissioner of Taxation stated that, I quote, "The separate legal personality of a company is to be disregarded only if the court can see that there is, in fact or in law, a partnership between the companies in a group, or that there is a mere sham or a facade in which that company is playing a role, or that the creation or use of the company was designed to enable a legal or a fiduciary obligation to be evaded or a fraud to be perpetrated." Dear students, now we come to the grounds on which the corporate veil can be lifted. In LIC of India versus Escorts Limited, it was signified that there should not be an exhaustive list of situations where the corporate veil is permitted to be lifted. Rather, it should rest on a case-to-case basis. And in the state of Uttar Pradesh versus Renu Sagar Power Company, the Supreme Court of India said its frontiers are unlimited. Dear students, the grounds on which the corporate veil can be lifted can be broadly divided into two categories. The first is the judicial ground, the second are the statutory grounds. We shall first discuss the judicial grounds. The first judicial ground is characterization of a company. Sometimes it becomes important to determine the character of a company, that is, to determine whether it is an enemy company or not. A leading case on the point is Daimler Company Limited versus Continental Tire and Rubber Company Limited. The facts of the case are, a company, Daimler Company Limited, was incorporated in England to sell tires in England. The tires were made in Germany by a German company. All the shareholders of the company except one were German. All the directors of the company were German, resident in Germany. Thus, the actual control of the company was in German hands. During the First World War, against Germany, the appellant company Daimler Limited claimed that it did not have to pay the money it owed to the respondent company. The appellant company argued that such payment would constitute trading with the enemy. The issue involved in this case was whether Daimler Limited was entitled to refuse the payment because the respondent company was controlled by the enemy. The House of Lords reiterated the basic principle that a company incorporated in the United Kingdom is a legal entity, a creation of law with the status and capacity which the law confers. It is not a natural person with a mind or a conscience. To use the language of Lord Justice Buckley, it can neither be loyal nor disloyal. It can neither be friend nor enemy. Such a company can only act through agents properly authorized, and so long as it is carrying on business in this country through agents so authorized and residing in this or a friendly country, it is prima facie to be regarded as a friend. The next point to remember is that such a company may, however, assume an enemy character. This will be the case if its agents or the persons in de facto control of its affairs, whether authorized or not, are resident in an enemy country, or wherever resident are adhering to the enemy or taking instructions from or acting under the control of the enemies. A person knowingly dealing with the company in such a case is trading with the enemy. In the instant case, all the shareholders of the company except one were German. All the directors of the company were German, resident in Germany. Thus, the real control of the company was in German hands. The court lifted the corporate veil and treated the company and its members as one and the same. In R versus London County Council, a local authority refused to renew a cinematograph license held by a company incorporated in England because a substantial majority of its shares were held by German nationals and 3 out of its 6 directors were Germans. The court upheld the refusal, holding that the control or at least the influence which the enemy nationals might exert over the activities of the company in exhibiting films was a relevant matter during wartime. Justice Bray said that it is clearly permissible for the council to consider when a company is the applicant who are the persons who control the company. The approach here is to consider the situation as if the shareholders were to obtain the license in their personal capacity and then decide whether the company ought to obtain it in its name. The next ground for lifting of the corporate veil is evasion of taxes. At times, tax legislations warrant the lifting of the corporate veil. The courts are prepared to disregard the separate legal personality of companies in case of tax evasions or liberal schemes of tax avoidance without any necessary legislative authority. In the case of Deenshaw Manekji Petit Re, the assessee, Sir Deenshaw Manekji Petit, was a wealthy man enjoying huge income from dividends and interests. He formed 4 private companies and agreed with each to hold a block of the investment as an agent for it. Each of these companies took over a particular block of investments belonging to the assessee. The schedule showed that of these 498 shares, 254 stood in his name and 200 in the name of his wife, and the rest in the name of some 13 other nominees. The 498 shares remained as they were in the safe hands of the assessee or of his nominees. So does the income also. He credited the income received by him in the accounts of the companies and took it back in the form of a pretended loan. The whole idea was to split his income into 4 parts with a view to evade taxes. It was held that the company was formed by the assessee purely and simply as a means of avoiding super tax, and the company was nothing more than the assessee himself. It did not make any business but was simply created as a legal entity to ostensibly receive the dividends and interests and to hand them over to the assessee as pretended loans. A landmark case of the Supreme Court is its decision in the case of Vodafone International Holdings BV versus Union of India and another. In its judgment, the Supreme Court of India set aside the judgment of the Bombay High Court directing Vodafone International Holdings BV, that is Vodafone, to pay 110 billion Indian rupees as withholding tax in a transaction that took place offshore. The facts, as briefly put, were that in May 2007, Vodafone Incorporated in the Netherlands acquired from Hong Kong-based Hutchison Group the entire share capital of CGP Investments Limited, a company incorporated in the Cayman Islands, which in turn controlled a 67% interest in Hutchison SR Limited. Hutchinson's Indian mobile business. The Indian income tax authorities contended that the capital gains were made by Hutchinson in India and that Vodafone was therefore liable to pay withholding tax thereon amounting to approximately 110 billion Indian rupees, the sale price being 11.2 billion US dollars. Vodafone challenged the tax demand in the Bombay High Court, which ruled in favor of the income tax authorities, holding that the essence of the transaction was a change in the controlling interest in HEL, which constituted a source of income in India. Vodafone appealed to the Supreme Court, which overruled the High Court and held that the transaction fell outside India's territorial tax jurisdiction and was not taxable. In this case, the court recognized the fundamental principle of the corporate veil by noting that the approach of both the corporate and tax laws, particularly in the matters of corporate taxation, generally is founded on the above-mentioned separate entity principle, that is, to treat a company and its members as separate persons. The Indian Income Tax Act 1961 in the matter of corporate taxation is founded on the principle of the independence of companies and other entities subject to income tax. It observed in the context of parent-subsidiary relationships that it is generally accepted that the group parent company would give guidance to group subsidiaries, but that by itself would not justify the piercing of the veil or imply that the subsidiaries are to be deemed residents of the state in which the parent company resides and that a subsidiary and its parent are totally distinct taxpayers. The 6 factors that may be considered to determine whether the transaction is a bogus transaction and whether in a specific case the corporate veil may be lifted are: number 1, the concept of participation in investment; number 2, the duration of time during which the holding structure exists; number 3, the period of business operations in India; number 4, the generation of taxable revenues in India; number 5, the timing of exit; and number 6, the continuity of business on such exit. In the final analysis, the Supreme Court decided against the lifting of corporate veil in Vodafone as the tax authorities failed to establish that the transaction was a bogus or tax avoidance scheme. Where a corporate facade is really only an agency or an instrumentality. Under the ordinary rules of law, a parent company and a subsidiary company are distinct legal entities, and in the absence of agency contract between the two companies, one cannot be said to be the agent of the other. In order to hold one company liable for the acts of another, it is important to establish the relationship of agency. In Smith, Stone and Knight Limited versus Birmingham Corporation, the court laid down 5 tests to determine when one company can be considered to be an agent for another company. That is, the court laid down tests for the lifting of the corporate veil and recognized the principal agent relationship between a holding company and a subsidiary company. They are: number 1, that the profits of the subsidiary's business should be treated as the profits of the holding company. Number 2, the person taking care of the subsidiary's business should be appointed by the holding company. Number 3, the holding company should take care of the business of the subsidiary and decide as to what should be done, how and when it should be done. Number 4, the profits of the subsidiary should be as a result of the skill and direction of the holding company. Number 5, the holding company must have an effective and constant control. In Ray RG Films Limited, an American company produced a film in India, technically in the name of a British company, 90% of whose capital was held by the president of the American company, which financed the production of the film. The Board of Trade refused to register the film as a British film, which stated that English company acted merely as the nominee of the American corporation. However, in the case of Adams versus Cape Industries, the court was unable to pierce the corporate veil because the company's activities were not matching with any of the tests that was established in the previous case, that is, the case of Smithstone versus Birmingham Corporation. The company was doing good and in fact was generating revenue and profits for the holding company. The next ground for the lifting of the corporate veil is fraud. Piercing the corporate veil may be justified when the formation and subsequent existence of a company constitutes a fraudulent abuse of the company. The fraud exception considers the formation of a company to be a sham or a facade. To justify this exception, a company must have been formed for an improper or illegitimate purpose. Ordinarily, the fraud exception will operate where the underlying motive for formation was to enable the company's human constituent to impugn a pre-existing obligation with a third party, that is, to evade contractual obligations. An example of cases in which the veil of a company is pierced on the ground of fraud exception was the Guilford Motor Company Limited versus Horne. In this case, Mr. Horne entered into a contract with Guilford Motor Company Limited by which he agreed to abide by a restrictive covenant which provided that should he leave Guilford's employment as he was a managing director of Guilford Motor Company, he would not solicit their customers. Upon leaving Guilford's employment, Horne, through his nominees, formed a company, J.M. Horne and Company Limited, in which his wife and an employee were sole shareholders and directors. He thus impliedly sought to escape the terms of a restrictive covenant. The court held that the company was a sham, an alias of Horne, and as such an injunction was granted to enforce the covenant. The restrictive covenant was enforced against both Horne and the company. That is, the company's corporate existence was not denied, although the company's corporate veil was pierced to recognize Horne's personal culpability for the breach of the restrictive covenant. In effect, Horne had established the company as a fraudulent device to escape the terms of a pre-existing contractual obligation entered into with Guilford Motor Company Limited. These types of companies are regarded as a sham or a facade used to mask the real situation and justifies the lifting of corporate veil. Dear students, now we come to the statutory grounds on which the corporate veil can be lifted. The first statutory ground on which the corporate veil can be lifted is non-compliance with the conditions of incorporation. If the conditions of incorporation are not maintained, it is logical that the advantages of incorporation shall not be conferred on the company. For example, if the number of members falls below 7 in case of a public company and below 2 in case of a private company, and the company continues to carry on business for more than 6 months with the numbers so reduced, every person who knows this fact and is a member during the time that the company so carries on business after the 6 months becomes liable jointly and severally with the company for the payments of debts contracted after 6 months. It is only that member who remains after 6 months who can be sued. The second statutory ground on which the corporate veil can be lifted is misdescription of name. As per the Companies Rule 2014, a company shall have its name printed on every official document, including hundis, promissory notes, and such other documents as may be mentioned. Thus, where a company's officer signs on behalf of the company any contract or hundi or promissory note or a check or order for money, that individual shall be liable to the holder if the name of the company is not properly mentioned. The next statutory ground for the lifting of the corporate veil is fraudulent trading. Under Section 339 of the Indian Companies Act 2013, if any business of the company is carried on with the intent to defraud creditors of the company or creditors of any other person or for any fraudulent purpose, any person who was knowingly a party to the carrying on of the business in that manner is liable to imprisonment or fine or both. This applies whether or not the company has been or is in the course of being wound up. This was held in the case of Delhi Development Authority versus Skipper Constructions Company Limited. The next statutory ground for lifting of the corporate veil is in the case of holding and subsidiary companies. In the eyes of law, the holding company and its subsidiaries are separate legal entities. But in the following two cases, the subsidiary company may lose its separate entity. Firstly, if the company has subsidiaries, it must at the end of its financial year lay before its members in the general meeting not only its own accounts but also attach annual accounts of each of its subsidiaries along with a copy of the board's and the auditor's report and a statement of the holding company's interest in the subsidiary company. Secondly, the court may, on the facts of a case, refuse to treat a subsidiary company as an independent company. Dear students, now we come to other disadvantages of incorporation. The second disadvantage of incorporation is that a company is not a citizen. A company is a legal person, but it is not a citizen under the constitutional law of India or under the Citizenship Act 1955. The reason as to why a company cannot be treated as a citizen is that citizenship is available only to individuals or natural persons and not to juristic persons. The question whether a corporation is a citizen was decided by the Supreme Court in State Trading Corporation of India versus Commercial Tax Officer. The facts of the case are: the State Trading Corporation of India was registered under the Indian Companies Act of 1956 as a private limited company. Its head office was situated in Delhi and its entire capital was contributed by the Government of India. The sales tax authorities of Bihar and Andhra Pradesh had initiated proceedings to assess the sales tax of the corporation under their respective sales tax acts. Accordingly, these states issued notices of demand. Upon such notice, the petitioners, through a writ petition of certiorari under Article 32 of the Constitution, sought for quashing of the proceedings initiated by the state government. The corporations claimed that they were the citizens and alleged that such proceedings would infringe their fundamental rights under Article 19F and 19G. The issue before the court was whether the State Trading Corporation registered under the Indian Companies Act of 1956 can claim to be Indian citizens under Article 19 of the Constitution and whether the said corporation can claim the enforcement of fundamental rights under Article 19. The court, on examining the relevant provisions of the Constitution and the Citizenship Act 1955 regarding the present case, concluded that the corporation cannot be considered a citizen. It was stated that corporations may have nationality in accordance with the country of incorporation, but that does not confer upon them the right of citizenship. The court held that Part 2 of the Constitution and the Citizenship Act 1955 was exclusive only to a natural person. That since the company is not treated as a citizen, it cannot claim the protection of such fundamental rights as are expressly guaranteed to citizens, but it can certainly claim the protection of such fundamental rights as are guaranteed to all persons, whether citizens or not. In 1969, when the Bank Nationalization Ordinance was passed by the then President V.V. Gary, and later this ordinance was repealed by the Banking Companies Acquisition and Transfer of Undertakings Act 1969, Rustum Kavashi Cooper, a shareholder and director of one of the 14 commercial banks which were nationalized, challenged the validity of the ordinance and the banking companies. One of the grounds for the challenge was that the provisions of the Act which transferred the undertaking of the named banks and prohibited those banks from carrying on the business of banking and practically prohibited them from carrying on non-banking business impaired the freedoms guaranteed by Article 19(1)(f) and Article 19(1)(g). The court allowed the petition on the ground that the petitioner claimed the Act and the ordinance impaired the rights guaranteed to him, that is, to the shareholder, under Articles 14, 19 and 31 of the Constitution. Thus, the maintainability of the petition was based on the infringement of R.C. Rustum's rights and not that of the company under Article 19. However, the court specifically mentioned that where the shareholder's right has been infringed along with the rights of the company, the court cannot deny itself action merely on the technical operation of the action. The present scenario is that a corporation cannot claim citizenship and cannot therefore claim any rights under articles which are specifically dealing with citizens. though the shareholders of a company can challenge the constitutional validity of a law on the ground of infringement of any article like Article 19, Article 16, Article 30, etc., which protects citizens if their own rights are infringed, and in such cases, the fact that the company's right is also violated will not act as a hindrance or reason for dismissal of petition. Bennett Coleman and Company and others versus Union of India and others is another important case in relation to determining whether a company can have the freedom of speech and expression. In this case, the subclauses 3 and 3A of Clause 3 of the Newsprint Control Order 196233 passed by the Government of India under Section 3 of the Essential Commodities Act 1955 and the provisions of the Newsprint Import Control Policy for the year 1972-73 were challenged on the ground that they were violative of the fundamental right under Article 14 and Article 19(1)(a) of the Constitution by the newspaper company. The Supreme Court held in this case that the fundamental rights of the shareholders as citizens are not lost when they associate to form a company. It can be said that the court, to a certain extent, went few steps back, and the court stated that because the individual rights of the freedom of speech and expression of editors, directors, and the shareholders are all expressed through their newspapers, barring relief to a newspaper company who is not a citizen will actually lead to the infringement of the fundamental rights of the shareholders who are also the citizens of India. The next disadvantage of forming a company is procedural formality and costs. Incorporation of a company is a costly affair. Besides, it involves completion of a lot of formalities. Moreover, the administration of a company has to be carried on strictly in accordance with the provisions of company law, and its activities are limited by its memorandum. Thus, procedural formality and costs at times creates impediments in its working. Dear students, in this lecture, we try to understand the disadvantages that flow from the incorporation of a company. We also try to understand what is meant by lifting of the corporate veil. We also try to understand what are the grounds on which the corporate veil can be lifted. That is all in today's lecture. Hope you understood fully. Have a nice day.